Hey everyone, welcome back to the channel. Today we are diving into an important topic, renunciations in the context of a grant of letters of administration here in Singapore. Before we dive into renunciations, let's take a quick look at what letters of administration actually are. When a person dies without a will, that's what we call intestate. The court needs to appoint someone to handle the distribution of the dead person's assets. The person appointed is known as an administrator, and they receive what's called a grant of letters of administration, which is essentially a court order, to officially act on behalf of the estate. Now let's talk about renunciations. Sometimes a person who is entitled to apply for a grant of letters of administration may not want to take on the responsibility. In such cases, they can renounce their right to apply. Renunciation means giving up the right to act as the administrator of the estate, but it doesn't mean that he's giving up the right to inherit under the Interstate Succession Act. But it's important to understand that renunciations are formal legal documents. They are not just a casual, no, I don't want to do. Renunciations are used when someone who has priority to act as an administrator doesn't want to take on that role. Under Singapore law, specifically the Interstate Succession Act, the spouse and next of kin generally have the priority to apply for letters of administration. But if, for example, an elderly mother whose son has died and the son doesn't have any children or wife or whatever, or a spouse or a sibling or child of a deceased doesn't want to take on the responsibility, they can file a document called a renunciation. Reasons for wanting to renounce can vary. The person who has priority to act as administrator may feel that they are not capable of handling the duties. They might live overseas, making it impractical to manage the estate. Sometimes they simply don't want to deal with the legal and administrative burdens. It is also common for older people who are illiterate or who find it difficult leaving the house to renounce their right as administrator and ask their children to be the administrator instead. So how does someone formally renounce their right to act as an administrator? The renunciation must be made in writing and filed with the court. The relevant legal provision governing this process can be found in the Probate and Administration Act. Specifically, Section 3 of the Act states that any person entitled to apply for administration may renounce the right to a grant of letters of administration. Once renunciation is filed with the court, the person is no longer eligible to act as an administrator, and the court will consider the next person in line to administer the estate. Let's consider a quick example. Imagine someone dies intestate, that means without a will, leaving behind a wife and 2 children. The wife has the highest priority to apply for letters of administration. However, if the wife feels unable to manage the estate, perhaps due to old age or other personal reasons, the wife can renounce her right to apply. In this case, the next in line, one of the children, can apply to be the administrator. And there you have it, a quick look at renunciations in the context of letters of administration in Singapore. Renunciations allow family members to formally decline the responsibility of administering an estate, and the process is governed by specific legal provisions. I hope this video helps clarify this often misunderstood area of probate law. Thank you for watching, and I'll see you in the next video.